Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, my name is Fathya Andhara Maulana. I'm from class A with the student IDs number E1A025135. I'm currently studying in Law Mayor, specifically in Jenderal Sudirman University, and this is my final project, which is a legal case response presentation for the course English for Law that is instructed by Madam Nisa, Roiyasa, S.Pd, M.ESOL. Today, I will be analyzing a significant Indonesian trademark dispute, which is the case of PT Terbit Financial Technology versus PT GoTo Gojek Tokopedia. There is a reason why I choose this case because I'm quite familiar with Gojek and Tokopedia because I use them in my daily life. And this is one of the most famous trademark dispute cases in Indonesia. This case is not only a landmark in Indonesian intellectual property law, but also a telling example of how procedural and substantive legal principles can clash in high-stakes commercial litigation. So let's begin with the background. The case started when PT Terbit Financial Technology, a fintech company, registered the wordmark GoTo on March 10, 2020. Under Class 42, which covers services such as software design, e-commerce platforms, and computer programming. The registration number is IDM 000858218. Later, in May 2021, exactly 1 year after it, two Indonesian tech giants, Gojek and Tokopedia, announced a merger, forming the name GoTo Group. Shortly after, they applied to register GoTo as their trademark. Also in Class 42, with a filing date of September 2, 2021, later registered under the number IDM 000936923. Well, the conflict arose when PT Terbit realized that a nearly identical mark was registered in the same class by a far larger competitor. They filed a lawsuit in the Central Jakarta Commercial Court on November 2, 2021, alleging trademark infringement and seeking cancellation of GoTo's mark. The main legal issues here are 1. Whether GoTo's mark has essential similarity to PT Terbit's prior registered mark, whether Gojek Tokopedia GoTo's registration violated the first to file principle, 3. Whether GoTo acted in good faith when applying for the mark, and the last one, whether the court's handling of the case was procedurally and substantively sound. So now, let's examine the relevant laws. Indonesia's trademark system is governed primarily by Law Number 20 of 2016 on trademarks and geographical indications. According to Article 3, trademark rights are obtained through registration. This embodies the first to file principle, which means the first registrant holds exclusive rights regardless of prior use. This means PT Terbit Financial Technology has the first to file principle. Next, under Article 21.1, a trademark application must be refused if it has essential similarity to an earlier registered mark for similar goods or services. Essential similarity includes similarity in sound, visual appearance, or concept. And you can see from the table that I have prepared here. So we can see the similarity between GoTo and the GoTo from Gojek and Tokopedia. The next one is, furthermore, Article 21.3 states that an application made in bad faith must be rejected. Bad faith includes intent to imitate, cause confusion, or free ride on another's reputation. Additionally, Indonesia follows the NICE classification system. Both marks were registered in Class 42, which includes software, e-commerce, and tax services. This classification strengthens the arguments that the marks are indeed competing in the same commercial space. Internationally, Indonesia is also bound by the TRIPS agreement, which requires member states to provide adequate trademark protection and prevent consumer confusion. So in this case, that is documented in case number 71 Perdata Kasus HKI Merek 2021 PN Niaga Jakarta Pusat, the Commercial Court dismissed PT Terbit's lawsuit. So let's evaluate this decision. The court's reasoning behind this is that the court ruled that the lawsuit was procedurally defective. First, it makes two distinct legal actions, trademark infringement and trademark cancellation, into one filing, which is not permitted, unfortunately. Second, the court held that it allowed jurisdiction to cancel a trademark that was still under examination by the Directorate General of Intellectual Property, or DJKI. The court's reasoning was formally correct. It upheld procedural discipline and respected the administrative authority of the DJKI. The ruling is consistent with established procedural principles that prevent judicial overreach into ongoing administrative processes. However, the judgment appears to be flawed in substance. By dismissing the case on procedural grounds, the court failed to address the core legal issue, whether GoTo's mark indeed infringed on PT Terbit's prior rights. The court's decision is questionable due to its avoidance of the good faith examination. There was evidence that GoTo was aware of PT Terbit's mark through prior business dealings, yet the court did not assess whether GoTo's registration was made in bad faith. I personally disagree with the outcome from a substantive justice perspective. While the court was procedurally rigorous, it allowed a potentially infringing mark to coexist with an earlier registered mark in the same class, the class 42. This undermines the first to file principle and creates legal uncertainty for trademark owners. A better approach would have been for the court to separate the claims, hear the infringement case, and refer the cancellation request to the DJKI with a recommendation. I believe that this would have balanced procedure with justice. Talking about the ethical and social implication, this case actually has broader implications beyond the courtroom. So the first one is for the legal system. It highlights a gap between procedural formality and substantive protection. If courts routinely dismiss cases on technical grounds, faith in the trademark system may erode. For businesses, it signals that larger companies may leverage legal procedure to override prior registrations, potentially stifling smaller innovators. And for the public, allowing similar marks in the same class risks consumer confusion and dilutes brand trust, contrary to the very purpose of trademark law. This decision sets a concerning precedent for how trademark disputes are resolved in Indonesia's fast-growing digital economy. So in conclusion, the GoTo versus Gojek Tokopedia's GoTo case is a clear example of how procedure can overshadow substance in intellectual property litigation. While the commercial court correctly applied procedural law, it left the substantive conflict unresolved. This exposes weaknesses in Indonesia's trademark enforcement mechanism. So I recommend some things. So the first one is PT Terbit should refile its case with clearly separated claims. So this is to avoid the confuse. Second, the DJKI should strengthen its substantive examination process, possibly using some tools to detect similarities and assess good faith. Third, Indonesian lawmakers should consider legal reforms to allow courts more flexibility in addressing substantive issues even in procedurally complex. So my final thought on this case is that this case is particularly complex, in which And the trademark law must protect not only the first to file, but also the principles of fairness, clarity, and good faith. Without this balance, I believe that the system risks becoming a tool for the powerful rather than a shield for the innovative. So that's all for my presentations. I wanted to say thank you for paying attention with this video, and I hope that you have a good day. I'm Fathya Andhara Maulana, and goodbye.